So, Attorney General, that two constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of Clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
other than 1 and
2. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction?
I can do that. But actually, if your Lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice, that constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of Clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render 3 OCOs completely. C will become OCOs.
C is
the provisions of the Constitution.
The C is something different. C dilutes the article itself.
C, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Madad. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And 1 is Madad integration. So that can't be touched. Part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched. C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. It doesn't say it's done.
By now, your lordships have, in fact, may I tell your lordship something interesting? Because I looked at the original Constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. It can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, come to that one. Let me show you. It's very fascinating.
Yes.
But take a bit of time. Let's kindly come to 370 presidential order.
Yes. That 1954 order.
1950.
Let's have a look.
50. Same volumes.
1950 or 54?
No, Malas, I'm coming to 50, Malas. Liquid text. Volume 3, PDS, page 4, Malas.
This is what you were reading as 13. No,
that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. The other was on at 13. This is at 4.
This is at 4.
Okay. Yes.
Are you referring to CO number 10, Mr. Sibal?
Yes, absolutely. Well, let's kindly see the index of this. 3 pages earlier. Yes. See what has happened here. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes, yes.
The first page of the volume.
That's right.
You're looking at
There's
the
a whole
different
index of all the orders.
orders issued.
Yes.
Serial number 1 was superseded by serial number 5.
To specify.
Now read it with me. The order may be called the Constitution Application to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state. For the purposes of B1 of clause 1 of 370, the matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your Lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India, and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage, that happened later. Then you went, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, at PDF 6, page 17. Just for my Lord. PDF 6, page 17. Kindly see exceptions. Article 72(1), provisions of the Constitution applicable. So there was no doubt on this issue, Malad. Entirety of Part 5. But in Part 5, 72(1)(c), 72(3), 133, 134, those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications that the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modify. 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) says, refers to the power of parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the parliament can enact a law on the concurrent list.
It will be because of 1B, Malaz. It only tells you the methodology, Malaz, that's all. The point is, what my lord is putting to me is, the president can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my lord is putting to me. But Malaz, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone, it's the substantive interpretation of 370. Kindly see the first column, Malaz. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts, there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely. That's our submission. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply. It's not in the second schedule.
Let's go to this now the
54 order.
54 order.
Yeah, that's volume 3 again, page 13. That's it. 13 PDF. Yes. Yes. In exercise of the powers, you also have that? So exercise of the powers conferred by clause 1 of 370, President with the concurrence of the government of the state of Jammu is pleased to make the following order. The order may be called the Constitution Application to Jammu and Kashmir Order. So, Malaz, supposing the entire constitution was to be made applicable, Malaz, it would require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So, any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence, instrument of accession and concurrent list. And Article 1 and 3 are out of it. So kindly see, Malaz. Clause 2, the provisions of the Constitution which in addition to Article 1 and 370, in addition, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows, the same pattern.
So the exception made here is the entire constitution is adopted subject to the modification
Yes.
made there. Unlike
other
the
than 1 and
1950.
3, other than 1 and 3.
1 and 3 is already there.
That's right.
Unlike 1950 order, which had specific articles were made applicable. Now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying
It's
356.
part by part, not true, Malas. Part by, see part 1, no, part 2, part 3. It's part by part. It's not all.
Is 356 specifically excluded
No. At this
in
stage,
this, at this stage?
yes. Excluded.
It would be excluded at
After
this.
part 5, you have part 9.
Yes, come to page 15. 356 is excluded.
Yes.
So
at
the
this-
entire constitution was made applicable by the 1954 order,
Malas, it said,
except to the extent of exclusion.
Malas, this part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.
Mr. Sibbal, my learned brother may be, if with respect, right. I'll tell you another reason. I'll give you another, just apropos what fell from Brother Sanjeev Khanna. Just see now part 3. First, we'll just see one small provision, clause 2 of the order of 1954.
Correct.
Yes,
It says the provisions of the Constitution, which
yes.
in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications shall be as follows. Now, one thing is very interesting. The word only, which we found in the 1950 order, has been deleted in the 1954 order.
Right,
So only goes.
yes.
Now, let's go to part 3 for a moment, and just to test the hypothesis.
We'll just go to parts. Yes.
Now, just see clause C in
Yes,
part
clause-
3.
Clause, yes, I
Right?
got it, Malas.
It says in clause 3 of Article 16, the reference to the state shall be construed as not including a reference to the state of Jammu and Kashmir.
Correct,
Now, if you see Article 16(3) of the Constitution,
yes.
it says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local authority within a state or any requirement as to residence within that state or union territory prior to such employment or appointment.
Right,
Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
yes.
what was the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Malas, other clauses in respect of clause 3 of the Constitution came into the J&K Constitution later. And I'll show that to your lordship.
But is it your contention, therefore, that
Entirety of 16
that
applied.
16(1) didn't apply to the Jammu and Kashmir?
It did apply, it applied.
The part which is mentioned.
But how did it apply then?
No, part 3 applies in full. When it says part, your lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now, in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was columnar. So in the second
That's what I was
schedule-
saying. See, in the earlier, the manner of printing of the two notifications
Yes,
is slightly
Yes, that's
different.
all, that's
That's
all.
very good.
In the first one,
Has been
there is a
expressly
column,
Yeah.
it is a article,
Yes,
then what is the exception sort of
correct,
carved
correct.
out?
And the modifications, now it's.
Modification exception carved out.
So now
In
it's.
this, the way it is printed as I see it,
Yes.
when they say part 3, it means part 3 applies, but.
But these exceptions and
one
modifications.
column of modifications which were there
Yes.
are specified underneath it.
That's
Exactly.
exactly
That's
what it is,
exactly-
nothing, no difference.
Other than what has been exclusively excluded.
Yeah.
The rest of the part 3 applies.
That's correct, that's all that there is. That's all.
This is simple.
Like
I
16,
think,
1 and 2 apply.
this is simple, just come to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay,
The provisions of the Constitution.
yes.
This means the entire provisions of the Constitution.
Page 10, your lordships. PDF page 10?
Yes,
Yes.
that's the notification, 14th May 1954. 2, clause 2. The
Page
provisions.
13, not 10.
13 of the.
Or page 13.
Yes,
Yes,
13.
yes, page
Yeah.
13. You're right. The provisions of the Constitution,
Yes. Yes,
which in addition to Article 1 and 317, Article 317,
Yes.
because that's covered by
yes,
3.
yes.
Now, the provisions of the Constitution refers to the entire provisions of the Constitution.
Correct, correct. Yes,
Shall apply in relation to the state of Jammu and Kashmir. Full stop.
yes. Which,
Second-
the word
second-
also left the word out, which.
Yes, I'm aware of that. That second part says The exceptions and modifications subject to which they shall also apply shall be as follows.
Correct.
So thereafter, the exceptions are carved out
Yes.
with regard to each part of the provision of the constitution, which are either not to be applicable or applicable with modification.
Correct.
And if you go down, it specifically says 356 is excluded.
Yeah.
In case this was specific inclusion, they need not have specified 356 is excluded. Because by implication, 356, if not mentioned in the schedule, would have been excluded.
But with the greatest respect, when you say kindly read it, just see. Kindly see part 18.
The very fact that some articles have been
Kindly see
excluded,
page 18. Kindly see page 18. PDF page 18.
yes,
Which is this. See part 18. 352, the following new clause shall be added. Above that,
correct,
part 18.
correct.
And therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
Like part 18 applies, for example, part 18 applies,
Yes.
the modification is specified below that.
Yeah.
Then small clause B, 13, part 3, small b.
Therefore, there is no dispute on
The
that.
entire constitution has been
356,
applied.
357.
Except what
Exactly.
So these three articles of part,
Which shall apply shall be as follows.
Will not have. That's correct.
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply? They are enumerating the provisions, that's all, Madam.
the next after that is what are the modifications?
Yes,
Or what is omitted. So
that's right.
mostly they are modifications, but some are omissions.
Yeah.
For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
19, other than this will apply.
That's right.
The approach is instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But
But
ultimately.
what about those parts which are not specified as parts?
They don't
They
apply.
don't apply.
No,
That is a problem. I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
Well, that's what, the only.
And this is significant.
I think 15.
PDF 15. no? The part your lordships are referring to is?
If everything applies.
Yes.
Why were they specific?
Yes. So part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification.
Well, that, with
where
respect,
there is
that's not the
modification, then
understanding-
specify.
That's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding, Malad, of any authority. Then, Malad, now we are saying, no, that was all wrong. Actually, everything
We're
applies.
not saying, we're just
And they don't,
discussing.
and you don't need consent.
Mr. Sibal, as I see it,
Yes.
every order
Yes,
extended different parts of the constitution
that's right.
to Jammu and Kashmir. Now, if a particular provision is with modification, it says so. Now, it may be by provision wise,
Yes.
or it may be part wise,
Yes,
it may be by any method,
correct.
but it keeps on extending by the
Yes,
orders
yes.
which are passed.
Yes.
So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes,
with certain modifications.
that's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only, and in any case, Malad, 1 and 3 are, 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Malad, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the constitution. So we can, Malad, interpret the orders any which way you want, but it cannot touch 1 and 370.
The two major points to my mind are this. One is your submission that Article 370 has acquired a permanent feature of the Constitution.
Yeah.
That's the debatable issue.
That's
which both sides will debate. Next is suppose it is not permanent. Then what is the manner of abrogating Article 370? Is that procedure followed or not?
That's correct.
The only two issues as I
Correct,
see it
correct,
in the
correct.
whole
But I'll
issue
hope
tonight.
and try and convince you that it is permanent. I will try and convince you. I know, Malad, your lordship says it's debatable and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this point
Yes,
out.
it's really debatable. But I tell your lordship, Malad, why it is permanent. Malad, now, for the moment, Malad, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether
course.
the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, Malad, so far I've only referred to provisions of this Constitution. But Malad, your lordships will have to look at the Constitution of Jammu and Kashmir. Because that Constitution, Malad, was framed and cleared in 1957. So, Malad, Malad, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, you can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah, Manoj, I'm sorry, my understanding is right. Before we go to that, Manoj, kindly see the volume 1, PDF 132. What date is this?
You are wanting us to go to PDF 1 now.
PDF is the date.
Volume 1 page, Mr. Siddle.
Manoj, volume 1, page 131. 132, Manoj. Now, Manoj, kindly see, this is the Constitution of India as applicable to Jammu and Kashmir just before abrogation of 370. And you'll see
Sorry, Mr. Sibbal, which page?
page PDF 132.
In the same volume?
Yes, volume 1. Volume 1, Manoj, not 3. One second. Now, Manoj, your lordships will see the table of contents at page 43 first.
Which page? You said 132, 43, which one?
Sorry, 43 first. Manoj, it's a table of contents are set out.
It will take a little longer to get to it.
Sorry, Manoj, sorry about that.
It's our fault, Manoj. We are prompting you.
Page 46 or
43, 40. But the contents, volume 1,
Yeah.
looks somewhat like this.
There's one
The
little
Constitution
improvement
of
which we have
India.
to make in our written submissions format. In fact, I'm just in the process of issuing a standard operating procedure for filing written submissions on all matters before CB, which is that the index should be hyperlinked.
That's the
So they'll be much easier for all
Yes.
the lawyers and for us also. We go to the index and just click on the hyperlink there.
43 is what you are saying?
Yes,
Yeah.
the index.
46 is the index.
Yes. Now, kindly see, Manoj,
Index actually
see-
starts earlier. Index starts from page 43.
Yes, 43.
43.
No, 43. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there is no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016, but it's as it stood there.
Now you see here, Manoj, after part 6, you have part 11.
Part 6, what page is that, Mr.
Well,
Sibal?
part 6 is at page PDF 48. And the next is, yes. Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why, Milad, the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only,
Yeah.
the word which seems to indicate that these are the
That
parts,
will-
the provisions which will apply.
So that's Mullah's really. Now, Mullah's in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember, Mullah's, yes, right.
Publication or government publication?
It's not a government publication, Mullah's, but this is not hopefully not in dispute, Mullah.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the constitution to Jammu and Kashmir. They never treated it as if all provisions apply. Though really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, Milad, we move on to what happened in 1957 when the Constituent Assembly, Milad, drafted this constitution and was adopted. Right. And Millers, remember the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want.
57, what happens at 57? Let's see then.
Yeah, but I'm just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then Miller's 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and be like any other state. They chose not to. And you will see that, Miller's, in the Constitution itself. I'll show Miller's. It's better we look at the
There is
Constitution.
no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character, which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct.
That's the first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
The methodology was wrong.
methodology was wrong.
No, sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is continuous, always. Second part is transitory because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner
Yes.
whereby some part will go away or become
Yes.
otiose, and some part becomes otiose because in 1957, some
Correct.
other part becomes otiose
Correct.
later on. So you say one has a permanent feature. That is our
So the
argument. we
Constituent
wanted.
Assembly effectively had a choice to exercise three or to allow one to
Till
continue forever.
1957. Your argument is all these choices were available only till 1957.
Yes, that's our
That is your argument.
So much. No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the
That's correct.
Maharaja of Jammu and Kashmir,
Correct.
acting on advice of the Council of Ministers for the time being.
Right.
Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we
Governor-
get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there, madam. It is part of the constitution, madam. I'll show that.
This explanation was introduced in 1952. This ex-
There's a difference of opinion here.
Leave it. You can.
Of us, not. Their case is that 2 and 3 may cease post 57. But the some of us whose argument is that no, the entity goes if we read clause 2 carefully. So this is that difference of opinion.
So your submission.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
50, 67.
Yes, 1965 order.
65. So till 65, did the Maharaja continue to have?
Yes, madam. Then,
There were
for-
separate powers of Sadr Riyasat.
Yes.
The
but madam, ultimately,
equivalent of chief minister is called the prime minister.
Yeah,
For a
that's
long
correct.
period of time.
But
And
in
those
65, madam, it was
were,
the governor.
removed.
There's an order to that effect. So be that as it may, madam, I think we're traveling a bit too far at the moment.
And then governors, then they could order. It's not anything that was done under the 70. JK.
Now kindly see, madam, the preamble of the constitution, your lordships will find, volume 2, PDF page 16.
Now we are looking at the J&K constitution.
That the Constitution of India is applicable under J&K Constitution.
JNK constitution.
J&K Constitution.
So that is volume.
Volume 2, PDF page 16. Yes. No, J&K.
You want us to go to page 16 of the
Page
JNK
16. Yes, the entire volume is that. Your Lordship has the preamble? That's why that explanation. No, he. Till 65, still 65. There was an order in 65. Well, just kind of page 5, PDF page 5, um, volume documents, volume 2. Just it's the index, Mullah, really. Right. Right.
So you referring to preamble at page 16.
Yes, but before that, Mullah, just so that you know Mullah, what the Constitution was dealing with.
Page 5 is part 3, you are saying.
Page 5,
You're wanting us to read page 5?
contents, Mullah. Contents. The state,
Yes.
permanent residence, directive principle of
that's what I'm
state
saying.
policy. PDF 5.
Yes.
Just the contents, Mullah. Yes. You see now, part 1, part 2, part 3, part 4, and the directive principles of state policy now come in. Permanent residence come in. Then the state, permanent residence, directive principle of state policy, executive, governor, council of ministers, advocate general, contractor, government of business, composition.
Just 1 minute, Mr. This goes against Speaker's directive.
Officers of the state legislature, disqualification of members. It's really a replication of what the Constitution, our Constitution provided. Procedure for financial matters, legislative power, high court, subordinate courts, finance, property, public services, elections, amendment to the Constitution. This is very important. I show that to your lordships presently. And then the schedules, speaker, deputy speaker, and all that. Now kindly come with us to the preamble. PDF page 16. So, we the people of the state of Jammu and Kashmir. Now, the Constituent Assembly has exercised its powers. Drafted the Constitution, adopted. We the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define, this is important, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's Article 1. And to secure to ourselves justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among us all, fraternity, assuring the dignity of the individual and the unity of the nation. In our Constituent Assembly, this 17th day of November 1956, do hereby adopt, enact, and give to ourselves this Constitution. Now kindly see the definition clause. In this Constitution, unless the context otherwise requires, the Constitution of India means the Constitution of India as applicable in relation to the state. Right? Then kindly come to Muller's Article 3, the state. Relationship of the state with the Union of India, the state of Jammu and Kashmir is and shall be an integral part of the Union of India. And Muller's subclause 3 says, just above that, any reference in this constitution to the Sadr-e Riyasat shall, unless the context otherwise required, be construed as reference to the government. This is 1960, which my lord was asking that question. So, Mullah, it shall be an integral part of India. And then 5, Article 5, the executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Then, Mullahs, the issue of permanent residence is dealt with. We're not concerned with that so much. And then you come to 35, page 28, PDF 28. This is an important section, Malaj. Important article. 35. My lords have that. PDF 28. Council of Ministers to aid and advise the governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions. All functions of the governor, except those under sections 36, 38, and 92, shall be exercised by him only on the advice of the council of ministers. So other than 36, 38, and 92, Malaj, he will act on the aid and advice of the Council of Ministers. Now kindly come to 38, 48A, PDF page 33. This was inserted, Malaj, in 1975. Notwithstanding, notwithstanding anything contained in this constitution, if upon the completion of a census, but before the final readjustment of territorial constituencies, the Legislative Assembly is dissolved prior to the expiry of its duration and the governor is satisfied that holding of general elections without delay is necessary, he may, after consulting the Election Commission by notification, direct that the general election shall be held on the basis of the last preceding delimitation of territorial constituency. Then, let's page Article 53, page 37, PDF 37.
Article
53, Malaj, at PDF 37. That's the session of the legislature, prorogation and dissolution. The governor shall from time to time summon each house of the legislature to meet at such time and place as he thinks fit. But 6 months shall not intervene. These are the provisions of the Constitution also. Intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The governor may from time to time prorogue the houses or either house or dissolve the Legislative Assembly. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38, and 92. This is important because it really, the issue will arise because Malaj, there was no Council of Ministers when he did this, which is on the 21st of November, 2019. 2018. Malaj, the importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38, and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. Well, I'll come to that later. Now, Malaj, 92, which is that exception. PDF page 59. This is a very unique power given to the governor of Jammu and Kashmir. Yes. I was mentioning, Millet, as far as 53 is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38, and 92. And I'm now reading 92 for your lordship. This is also a unique provision. Provisions in case of failure of the constitutional machinery in the state. This is PDF Mullahs 59. My lords have that. Does this call, Mullahs? Does your lordship have one?
Page 50.
59, PDF 59, Article 92. My lord have it.
Breakdown of.
Yes. Now, provisions in case of failure of the constitutional machinery, if at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may by proclamation, Mullahs, assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by any body or authority of the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to anybody, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in or exercisable by the High Court. We are not concerned with that. But Mother, this he can exercise without the Council of Ministers, unlike in the Constitution of India. Why? Because Jammu and Kashmir has a unique status in the context of its relationship to the government of India. Yes. Huh? And Miller's clause 3 of this is important, that any such proclamation, whether varied under subsection 2 or not, shall, except where it is a proclamation revoking a previous proclamation, cease to operate on the expiration of 6 months from the date on which it was first issued. So, Maharaj, the proclamation was issued on November 21st, 2018, on 20th of June. It was to expire in 6 months' time, on 19th December. And Maharaj, on November 21st, he dissolved the assembly. And without reference to the Council of Ministers. But anyway, we'll come to that a little later. Now, most important, well, is in the context of what we've been arguing all of yesterday and today, is 147, PDF 85, sorry. Oh, sorry.
Amendment to the Constitution.
Yes. Well, an amendment of this Constitution shall be initiated only by the introduction of a bill for the purpose in the Legislative Assembly, and when the bill is passed in each House by a majority of not less than 2/3 of the total membership of that House, it shall be presented to the Governor for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Council and passed by it by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment, now this is important, provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5 or the provisions of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the legislature. So, Maharaj, you cannot amend 370 as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no constituent assembly. It was temporary, it had to be temporary. Per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian
Yes, because,
Constitution?
brothers, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, brothers, kindly. Subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly the
Those-
doesn't have.
That legislature doesn't have those powers. Ultimately, what happens is when you impose Article 356, you took over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, brother.
Mr. Sibal, how
But then
can
how
we,
is proviso C will applicable?
Yeah.
how can, you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt you, Lord.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
Exactly.
But that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you are saying is Legislative Assembly cannot exercise the power under the proviso to
Yes, yes,
clause 3
yes.
of Article
So what,
370.
then
That's
what,
not-
that's why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malaj. This is what is shocking.
The lighter side, the Parliament did it.
I'm sorry?
On the lighter side, the Parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means, but we'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Millers, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised, is the powers of the legislature, nothing more than that. That's the whole scheme of 356 is if you take
Whether
over.
the Parliament can do it or not.
Yeah, but Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers, now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370, Manoj.
But this is in that sense a subordinate instrument in its application to the
Manoj,
in its
it's
relationship
a
to the
subordinate-
Constitution of India.
Manoj, kindly see, one second, kindly see, just 1 minute. Huh? Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Manoj, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what
Legislature
you're
cannot
saying.
change. Why? Because this is not a temporary provision. Come to that. That's clear, Manoj. Section 3. This Constitution. Same thing. Section 3. The Legislative Assembly also can't touch below the provisions that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't touch extent of executive and legislative power of the state. Can't touch that. And it can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question, the proviso to Article 147 of the J&K Constitution says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable
Yes.
in relation to a state
Yes.
means a change in the Constitution of India. Whereas, as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the,
Recommendation. Neither consent nor consent. It's a recommendation
no. if
of
we-
the of the legis
Let's
of
see
the Constituent
373.
Assembly.
Let's see 373 for a
Yes,
minute.
please.
So really speaking, under 147 may have no application as far as, because you're not seeking to amend 370, but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly. On the recommendation,
Yeah.
let's assume so.
Let's. Yeah,
Let's substitute, you're right,
Correct.
recommendation.
correct.
Let's substitute that word, provided that the recommendation of the Legislative Assembly for the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, Malaj, kindly see what 147 says is the provisions of the Constitution
But
of India
you're not
as
amending the.
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. For the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the
As it applicable in
which
relation
is,
to the
which is
state.
why 370 is incorporated, Malaj, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order. We're not talking about the Constitution of India here.
Sibyl, doesn't it, I'm just thinking aloud.
Yes.
Does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
Yes.
you through an amendment cannot
That's all
deactivate
that
it.
we are saying. Nothing
You
more.
can deactivate a provision which has already been applied to the
Yes,
Constitution
that's all that we are saying.
of,
Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. Yes. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
as I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and you start
That's all. That's all.
and say that, look, okay, we don't want to make some of the Constitution provisions
Absolutely.
already made applicable,
Correct.
not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356. So now, Malaj, this is now the lay of the land as far as this is concerned. Now I want to take your lordships to the judgment of Supreme Court, Malaj, of this court in the power of the constituent Keshav Nand, Malaj. Volume. This is it? T. No, no, no. Then I come.
So, Sibyl, is the factual whatever you had to say is over?
No, no, Maharaj. I'll go back because we are on the point of the Constituent Assembly and the Legislative Assembly. So Maharaj, that has to be clarified. Maharaj, you can't, a Legislative Assembly cannot be converted into a Constituent Assembly. My basic argument is that. Under what power can you convert a Legislative Assembly into a Constituent Assembly? Which is that power?
As a matter of fact, Praja Sabha was turned into a constituent assembly, 1951.
Well, there was a direct election, I believe, well, at that point in time. Rajya Sabha was not all directly elected. But I'll check that out. But I don't want to make a statement, and I'm sure of it. No, there was not. I mean, I don't want to give an answer without being sure of it.
Unless you are sure about it.
That's right. I always hesitate to do that. My learned friends are far more, articulate on those issues than I am.
Seized by the Raja, 2051. Just about by the power of Praja Sabha was conferred to the Constituent Assembly.
The power of constituent assembly was conferred on the Praja Sabha.
According to me, and I'll give that date, why should I say anything? The Constituent Assembly was directly elected in Jammu and Kashmir, but I don't want to, I must be sure of it before I say that. I know it says that Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution. So I was aware of it, but I was not sure where it was. I just wanted to mention. Unlike Unlike us, we were indirectly elected, our constituent assembly. Anyway, let's kindly have a look at Keshavnan Bharati. This is volume 15. Volume 15 of
Yes, that's a good idea.
Case Law Compilation, PDF 236. Actually, 235. I'll start with paragraph 537. Volume 15, my lords. Volume 15, paragraph 537. Which is why I've been saying throughout my summation, this was a political act to achieve a certain political purpose, dehorse the provisions of the Constitution. Page, my lords, 235, paragraph 537.
We've got it on the screen as well.
Yeah.
Sorry, Mr. Sibyl, sorry. I just wanted to answer my Lord Justice Gavai's question. I just sought to be unmuted. My Lord, there was a proclamation by Yuvraj Karan Singh for constituting the Constituent Assembly on 20th April 51. It was elected by adult suffrage. This was convened on the 31st of October 1951, its first sitting, and Melodic concluded its work on the 17th November 56, when it decided to adopt the constitution on the 26th of January 57.
That's correct. Well, it's page para 537 of PDF 235.
Whose judgment is this?
This is Malad's Justice Sheraton Grover. Well, the argument was that
Which page are you number?
368 refers to procedure to
You are
amend the
referring to
Constitution.
page number?
Page 5, PDF 235.
235.
Volume 15, Mr. Sibbal.
I'm sorry,
Volume 15.
volume 15.
Case law compilation.
Volume 15.
Case law
Case
compilation.
law.
You also have that?
No, we have got something else.
Page 235.
It's with you, in case you want to see it on the screen.
Eight.
We've got it on the screen.
537, 538, Malaz. I just read 37. The argument was, Malaz, that when the Constitution in 368 talks of amendment to the Constitution, it's a procedural argument. Where does the constituent power lie? That was the argument, and that in that context, the issue of what is a constituent assembly,
Yes.
that is discussed, Malaz. It's in that context because we're dealing with that issue. 537, if I may read. It is pointed out on behalf of my lords, all my lords have
Yes.
it. It is pointed
I
out
just
on behalf
want- you got it? Oh, yes.
It is pointed out on behalf of the petitioners that the scheme of Article 368 itself contains intrinsic pieces of evidence to give a limited meaning to the word amendment. Firstly, 368 refers to an amendment to the Constitution, and the result of the amendment is to be that the Constitution shall stand
One
amended.
second.
No. Yes, 235. My lords have it, my lords, not yet.
No problem.
constitution of its identity. The amending power is conferred on the two houses of parliament, whose identity is clearly established by the provisions of the constitution. It must be the parliament of the sovereign democratic republic. It is not any parliament which has the amending power, but only that parliament which has been created by the constitution. In other words, it must continue to be the parliament of a sovereign and democratic republic. The institution of states must continue to exist in order that they may continue to be associated with the amending power in the cases falling under the proviso. If the respondents are right, the proviso can be completely deleted since Article 368 can be amended. This would be wholly contrary to the scheme of Article 368 itself. Scheme of 68 because two agencies are provided for amending the provisions covered by the proviso. One agency cannot destroy the other by the very exercise of the amending power. The effect of limitless amending power in relation to amendment of Article 368 cannot be conducive to the survival of the Constitution because the amending power can itself be taken away and the Constitution can be made literally unamendable by virtually unamendable by providing for an impossible majority. While examining the above contentions, it is necessary to consider the claim of the respondents that the amending power under 368 has the full constituent power. It has been suggested that on every occasion the procedure is followed as laid down in Article 368 by the two houses of parliament and the assent of the president is given, there is the reproduction of the functions of a constituent assembly. Just mark. In other words, the parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This is fundamental to the entire argument that I made. In other words, Parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This argument does not take stock of the admission made on behalf of the respondents that the entire Constitution cannot be repealed or abrogated by the amending power. Indisputably, a constituent assembly specially convened for the purpose would have the power to completely revise, repeal, or abrogate the Constitution. That shows that the amending power under 368 cannot have the same powers as a constituent assembly. Even assuming that there is a reference on the nature of the power being enacted between enacting a law and making an amendment, both the powers are derived from the Constitution. The amending power has been created by the Constitution itself. It can only exercise those powers with which it has been invested. And if that power has limits, it can be exercised only within those limits. So you have a clear distinction between the exercise of constituent power and the exercise of legislative power, which is what I said in the beginning to your lordships. Parliament, while enacting a law, functions within the contours of the Constitution. A constituent assembly has no constitution in place. It has every right to do what it likes till such time as the Constitution is framed. So at no point in time in law can a legislative assembly be converted into a constituent assembly as a matter of law. Yeah. Luckily, we had no Maharaja exercising his powers, because we had Parliament doing that.
And
Now,
even when Parliament amends the Constitution,
yes,
it's not exercising powers as a constituent assembly.
that's correct.
It may be exercising a constituent power,
That's correct.
the power to amend, but because it's a power which is restricted, You are subservient to the Constitution.
That's right.
And therefore, you're bound by the provisions of the Constitution, by virtue of which your power to amend the Constitution is circumscribed.
That's what I'd said at the outset, Mullahs. That has been my submission throughout. Now, the next paragraph, Mullahs, is paragraph 620. This is at PDF page 273.
Whose judgment is that?
This was Justice Hegde and Justice Mukherjee.
270?
Mullahs, 273 PDF, para 620 Mullahs. Otherwise, Mullahs, see the danger of this argument. Tomorrow, Mullahs, Parliament says that we are the Constituent Assembly. They can do away with basic structure.
Dr. Ambedkar also spoke about it in his speech on 25th of November, 1949.
I'm sorry, but I didn't get your note.
Dr. Ambedkar,
Yes,
while presenting the final draft
yes,
on 25th of November 1949,
yes,
also spoke about this aspect
yes, yes.
in his
Yes, I
concluding
think
speech.
we have it, I think. We have it, I think, in volume 8. I just come to that. No, the point I'm making is a more fundamental point which impacts the future of our country. If you, in principle, say that a parliament can convert itself into a constituent assembly, then where do we go from there? Forget about this case. I'm far more worried about our future. Parliament can never say that, because that constituent assembly is a political process, which I said at the beginning. It's a political process in the context of the aspirations of all those participating in the constituent assembly as to what the state should be like. How do you meet the aspirations of the different segments of the community which have to be met, and what kind of provisions should be put in place? So it's the genesis of the politics of the day which determines what kind of constitution we want. Which is why, when you talk about diversity, when you talk about minorities, we talk about Dalits, we talk in our constitution, what were we faced with? In 1947, what were we faced with? We were faced with a situation where disparate communities, diverse communities, different religions, different races came together to be part of the Union of India, and their aspirations had to be met. So you had provisions with the Dalits, you have provisions with the minorities, you had provisions dealing with reservations, the scheduled castes, the scheduled tribes. That's a political process. That's why our constitution is what it is. Unlike, as I told, in Europe, it was an entirely different process. Here it was an amalgamation of colors to be united as one, which is the Tiranga. That's what it is. You can't convert a legislative assembly into that process.
But equally, Mr. Sibal, to completely divorce the power of amendment from the political process inherent in the amending power
Yes, of course.
would not be appropriate, because there's no strict dichotomy in that sense between the exercise of the constituent power itself being traceable to the political process and the power of a constituent assembly being entirely political in its nature. The constituent power itself of parliament to amend the constitution is a political power.
I agree entirely. Absolutely right. We're not saying you can't amend. Because it's not our case. You can.
But when parliament amends according to you, it is not exercising the powers of a constituent assembly.
That's all that I'm saying. That's all that I'm saying. It's not converting itself. And then it has to function within the Constitution of India. I'll come to that later. We're at a stage, Malad, where a CO is issued.
The constituent assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. Absolutely. Absolutely, Malad. And it said, the judgment says so, Maharaj, that it's not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. I'm not Maharaj being political, but that's the worrisome part. May I read 620 Maharaj?
20.
Now coming back to Article 368, it may be noted that it has three components. Firstly, it deals with the amendment of the Constitution. Secondly, it designates the body or bodies which can amend the Constitution. And lastly, it prescribes the form and the manner in which the amendment of the Constitution can be effected. The article does not expressly confer power to amend. The power is necessarily implied in the article. The article makes it clear that the amendment of the Constitution can only be made by Parliament, but in cases falling under the proviso, ratification by legislatures of not less than one half of the states is also necessary. Normally, if you read the proviso, if you don't have the ratification, there will be no amendment. You can't wish away the proviso. That article stipulates various things. To start with, the amendment of the Constitution must be initiated only by the introduction of a bill for that purpose in either House of Parliament. It must then be passed in each House by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. And if the amendment seeks to make any change in the provisions mentioned in the proviso, it must be ratified by not less than one half of the state legislatures. Thereafter, it should be presented to the President for his assent. It further says that upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Maharaj, when your lordships talk about temporary, Maharaj, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency, it could not have been. And this is the marginal note. Give it to my lord. You have copies?
This is a marginal
Give it to
note.
the
There's
other
no
side.
question about it. It is a marginal note.
Yes. So, Maharaj, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
But there's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and
But those
special
are
provisions.
Maharaj, I'm not disputing that. These are all different provisions, Maharaj. If your eye look,
They've all been clubbed together in Part 21.
that's correct. But we looked at it in the context of, Maharaj, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry.
317. It is actually good. Actually, देखो क्या क्या मैंने
If you look at the heading, Millers, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercise the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the
10 minutes. Yes. Reason 7 is a different issue. It's on the definition. I don't feel so. Discuss that.
to apply the proviso to clause 3 of Article 317.
Yes, yeah, because they understood it that way that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly
Yes.
by virtue of the fact that the Legislative Assembly has been dissolved.
Yeah.
assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
That's right.
Now that it has been dissolved,
Yes.
under 356, Parliament has the power to make laws with all aspects of whether it's
Correct.
list 1, list 2, or list 3. And then they exercise the power under the proviso.
That's right. That's right. So, Malad, actually, they understood 370 sub-article 3 in the manner in which I am, Malad, stating before your Lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, Malad, so that now your Lordship knows, Malad, the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies. No, talk about.
We'll come back after lunch. Mr. Sibal, if you can just, in a very brief while, take us through the process which was followed. We can go straight to that. Now we've understood anything more in Keshananda apart from these four judgments? All right, we'll see that and then so that we come to the end of then reading Keshananda.
Yeah, 25th November.
And if your lordship sees the facts, I think it'll help. No
Where he said we enter a life of contradictions. That's how he
That's
It's about his amending powers also. in
That's
that.
right, he covers it. He covers it.
Because criticized on both the sides.
That's right.
It's too liberal and too rigid.
Obliged. Deeply obliged.
Yes, Mr. Sibal.
Well, I was reading Keshavan Bharati at paragraph 620 at PDF 274. Let me finish that. So they talk of the marginal note as I was reading. And that's the language of 368 to our mind is plain and unambiguous, that paragraph. The bottom of 620 minutes. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. The language of 368 to our mind is plain and unambiguous. Hence, we need not call into aid any of the rules of construction about which there was a great deal of debate at the hearing. That the power to amend under the article, as it originally stood, was only implied. The marginal note rightly referred to the procedure of amendment. Reference to the procedure in the marginal note does not negative the existence of the power implied in the article. Then they go on to say whether you can amend every part of the Constitution. We're not concerned with that. That's the basic structure of hearing, so we're not concerned. Now kindly come to paragraph 1117. That's at PDF 424. 424. This is the judgment of Justice Jagan Mohan Reddy.
Page?
Paragraph 1117, page 424, PDF 424. Where reference is made to Dr. Ambedkar's speech. That's a very interesting observation.
424 you said.
424 PDF, paragraph 1117. The question arose in the context that when the Constituent Assembly is sitting, we're passing this and clearing this Constitution by majority vote. And this is an unelected body. When you give that power to the Constitution, why do you need 2/3? It's in that context that Dr. Ambedkar answers that. Lordship has 1117?
Yes.
My Lord Justice Gawai, Justice Kaur? Yes. Reference may also be made to the fact that during the debates in the Constituent Assembly, it was pointed out that by many speakers that assembly did not represent the people as such because it was not elected on the basis of adult franchise. And some of them even moved resolutions suggesting that the Constitution should be ratified by the people. Both the claims and demands were rejected. Dr. Ambedkar explained that, and I quote, the Constituent Assembly in making a constitution has no partisan motive. Beyond securing a good and workable constitution, it has no axe to grind. In considering the articles of the Constitution, it has no eye on getting through a particular measure. The future Parliament, if it met as a Constituent Assembly, its members will be acting partisan, seeking to carry amendments to the Constitution to facilitate to passing of particular measures which they have failed to get through Parliament by reason of some article of the Constitution. which the Constituent Assembly has none. That is the difference between the Constituent Assembly and future Parliament. That explains why the Constituent Assembly, though elected on limited franchise, can be trusted to pass the Constitution by simple majority, and why the Parliament, though elected on adult suffrage, cannot be trusted with the same power to amend it. How prescient words of Dr. Ambedkar. So when you are actually trying to use the legislative power, then you do it with a partisan motive because you want to get a bill passed, you want to get a particular policy through. But when you're as a constituent assembly, you have no such motive. So you can't convert a legislative assembly into a constituent assembly. Because as a legislature, your intent may be partisan. At a constituent assembly, it can't be. Well, you're not passing any law. At the final stages of the debate on the amending article, Dr. Ambedkar, replying to the objection that the Constituent Assembly was not a representative assembly, as it has not been elected on adult franchise, that a large mass of the people are not represented, and consequently, in framing the Constitution, the Assembly has no right to say that the Constitution should have the finality which Article 304 proposes to give it. Said, sir, it may be true that this assembly is not a representative assembly in the sense that members of the assembly have not been elected on the basis of adult suffrage. I'm prepared to accept that argument. But the further inference which is being drawn that if the assembly had been elected on the basis of adult suffrage, it was then bound to possess greater wisdom and greater political knowledge is an inference which I utterly repudiate. So then, Maharaj, that's enough for this part of the discussion. Now kindly come to Quello, volume 3.
On the other hand, the Constituent Assembly of State of Jammu Kashmir was elected.
Yes, yes.
I'm saying on the rationale.
That's
Whether
right.
it should or should not be.
That's right.
It's simple, there's slight difference between Article 370 and what is stated here and what is the objective and purpose. One, there is an element of flexibility in 370. Let's not go into the fact specific how it was done in this particular matter. In the form of whether it's consultation or with prior with acceptance incorporate and become part of it. So when we read the proviso to clause 3, at the time when the constitution was adopted, obviously there was no constitution of J&K.
No constituent assembly.
And no constituent assembly. But obviously they were aware that constituent assembly is going to come up and going to do it.
Absolutely.
So why can't we, when we interpret the constitution, because if we accept the argument that clause 3 was not to become dead after the constituent assembly had enacted or except they had proposed the constitution, why can't we accept that argument that the constituent assembly, for the purpose of the proviso, could, in a sense, be interpreted also to include the legislative assembly, keeping in mind the fact that the parliament could have very well amended the Article 370 also.
No?
Number 2, that if the objective was not to close or not to put Article 370 in a straight jacket, which is obviously clear. It's a flexible article in the sense that you could, whether it's clause D or it's B1 or B2, you could keep on adding up to it and the orders passed reflect that.
That's nothing to do with 370 sub-article 3. There's no flexibility there. Where's the flexibility?
So it is incorporated in 3. If we accept it's incorporated in 3, that notwithstanding anything contained in the foregoing provisions of the article, the President may with public notification declare the article will cease to be operative or shall be operative only with such exception modifications from such date as it may specify. Yes, the proviso puts a precondition to it.
No, it's a flexibility at the instance of the Constituent Assembly, not at the instance of Parliament. Surely, Malad.
But then, when we are reading the term Constituent Assembly for the purpose of the proviso, at that time when it was enacted, it was in 1949.
But they contemplated it, Malad. They contemplated it. Why would they add the word Constituent Assembly in 370 when it was
Because
not?
at that time, we didn't have any legislative assembly for the state of J&K.
No, correct. But you had the orders. Well, I don't understand. The flexibility at the instance of the Constituent Assembly, but this power is given to the Constituent Assembly, not to the legislature. It's not flexibility at the hands of Parliament or the legislature, because 147 says there's no flexibility there at all.
So there are two parts to it. First is whether the Parliament could have done it. That's a separate argument. But when we interpret the term Constituent Assembly for the purpose of the proviso to clause 3, can we by implication, because at the time when the Constitution was enacted, at that time there was no legislative assembly for the state of Jammu and Kashmir. Is that factually correct? Answer is yes.
Yes, of course.
So then when we interpret the term over here, can we interpret it to include the legislative assembly?
But Manas, how can you interpret a term in a constitution which says Constituent Assembly as the Legislative Assembly? I don't understand, Manas. Under what concept of interpretation of the Constitution will you do that? There is no implied power. There is no express power. I mean, you can change any definition of any Constitution.
That may not be. That will be it. Look, the term Constituent Assembly, when it is used in the proviso to clause 3, at that time there was no legislative assembly.
For the purpose of framing the Constitution that the Constituent Assembly is formed. That's not Malad. There's nothing to do with the legislature, which is why Malad Keshavnand Bharti.
See, the explanation which has been enacted was afterwards, is sometimes in 1952. Explanation enacted and has been made part of part 1, clause 1, was probably in 1952, if I'm not mistaken.
It was there, Malad.
No, initially there.
It was amended later on. That's not it was there, but
it was there, it was amended
yes,
later.
yes.
Because at that time, then the legislative assembly was brought in. Council of Ministers was brought in. Because at that time, there was
The
no
word
council.
governor Malad was had to be.
There was no council of ministers at that time.
That was the Maharaja Malad. But that issue doesn't arise here. We're talking about Malad, a constituent assembly, the power of the constituent assembly. And you have now, there are now the Keshavan Bharti Malad's, fortunately and unfortunately sets the law.
Mr. Sibal, just as a, because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372.
Yes.
370 bracket 2. Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution? I find that in the proclamation of the Maharaja.
Malad, they are in the constitution debates, Malad.
I find that there's also a reference in the proclamation of the Maharaja which we read out yesterday. The reason I'm asking is this.
It's probably there, yes.
Sorry?
Karan Singh's proclamation, I think.
Yes.
Huh? I've already mentioned that in the Constituent Assembly debates. Iyengar Malad, your lordships will remember.
Yes.
I quoted Malad's
sentence. Yes, volume 8.
All there, Malad, yes.
Page 117. Mr. Gopal Swami Iyengar's.
Yes.
No, because when the Maharaja made the proclamation, when the Maharaja issued his proclamation on 5th of March
It was
1948.
contemplated by the constitution and the constitution makers that there would be a constituent assembly which would come into place, which happened in 1951.
Right.
That's what happened.
What happened first was that when the Maharaja made his proclamation in 1948, he spoke of a national assembly.
Yes, absolutely.
Right? He says, my council of ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a national assembly based upon adult suffrage. Then 5, the constitution to be framed by the National Assembly
Yes.
shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience.
right.
Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly
Yes.
came into existence. Now, your whole argument is, of course, that what is to be done by a Constituent Assembly cannot really be done by a Legislative Assembly, and therefore less so by the central government assuming the character of a Legislative Assembly under 356. That's the. What happens then if there is no Constituent Assembly?
I'm sorry, Mal?
What happens if there is no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Well, that is precisely between 1948 consultations, but your lordship will
No, now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment.
Correct.
373 postulates the Constituent Assembly has to give its
Right,
recommendation
right.
on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post 1957 India?
Let me answer that in two parts. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the instrument accession was signed, Mullah. After the instrument of accession was signed, those were transitional periods. And when the constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, as it then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this Legislative Assembly will have no role in regards to the amendment of the provisions of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of the
next question is, supposing there was no constituent, that's the next
how
question.
do we, then what
Well,
constitutional
if there was
mechanism would be
constituent
envisaged then?
If there were no constituent assembly and your lordships were sitting in 5, I would have answered that question, but luckily we have a constituent assembly. Because I can't answer a hypothetical question as to what would
How
have
would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no Constituent Assembly, because there is no Constituent Assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a constituent assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019, the President wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said in terms in 147 that no such bill can be introduced in the legislature.
By them.
By them.
I'm talking about, no, by them, where the constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu
So
and Kashmir.
according to you, no constitutional procedure
No.
shall be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, Millet, I've been
The
saying.
argument is that after 1957,
Yes.
the president ceases to have any power under Article, sub-Article 3
That
of Article.
power was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malaj, at that time it was temporary because there was nothing in place.
After 1957, sub-Article 3 has become OTOs now.
Yes, no, Malaj. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what? And they merged. That's another issue altogether.
So, Mr. Sabal, according to you, neither the assembly can do it,
Yes.
nor the parliament can do
Yes,
it.
yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
Yes.
other than, of course, if it is hit by basic structure,
Correct.
this is one provision which can never be amended.
Well, and let it put it differently. But let me put it, under what power will this take place? Let's assume Manoj can do it. If my lord
I'm just
put the
thinking
question to
aloud.
me,
To have a
under
pers-
which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically,
Then a political act can be, but there can be a political act.
And those negotiations,
Clause 1 is the answer to this. 370 clause 1, bit by bit, modifications, exceptions, applications have come. Now, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the constitution exercising the 368 power to abrogate 370?
No.
Which means therefore that there is a provision of the constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So we are creating then a new category apart from basic structure.
No, not
That 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used, continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
not done.
Want to put
Yes.
is that 371, according to 370 subclause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the constitution applies to the state of JNK.
Yes.
Then what remains of 370?
Nothing.
Then the only,
Then to say that you can,
It can
in
be
a
taken-
sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are
be.
saying that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I'm.
This is what we are saying.
Yes, yes, sir.
That,
Yes.
that may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that'll, I think, Mr. Shankar Narayan, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance, of.
Because, respect Mr. Sibal, he knows the law. He also therefore didn't jump and answer the questions.
I think, see, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi said,
can.
no, this is not what I'm saying something different. So we'll have to see where the correct.
You
I
can say
understand. So
something
your
different. There's no
argument I've
issue at
understood
all.
at your own turn. He says that you can keep the shell, but the process is to 370 and
There
1.
is another interpretation.
Well, that's, the problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's
So why
saying there
not-
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay, I-
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provisions of the constitution apply and list them all of them and say all of them apply?
The problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
It doesn't apply to the other parts.
insofar as clause D is concerned,
Yes.
there are no limitations. If you read it, much of the provisions of the Constitution shall apply in relation to the state subject to such exceptions and modifications as the President may by order specify.
Correct,
This is governed by second proviso,
correct.
provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government.
Yes.
The treaty of accession, defense and commerce and
That's
so on.
correct, that's correct.
So if-
And the lists involved there.
And the list involved.
Correct.
So suppose if the parliament
Yeah.
decides to make the entire provisions of the constitution applicable to Jammu and Kashmir.
Yes.
Limitation under clause D.
Yes, there is. That's the point I'm making, Malaz. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those powers
Concurrent
under-
list and instrument of accession are two separate things, but there's no issue there. They can do it, both under 371, no issue.
insofar as instrument of succession, those
Only
entities are
four- only
concerned,
four items.
Their only requirement is consultation. Consultation.
That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that your lord is making, my lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of
Let's
basic structure.
all right, let's not talk of 2023, Madhaj. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how can
this-
we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madhaj. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened-
Unlike other states where Junagadh, Malaj, he didn't agree, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But
Malaj.
that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, but so then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Malaj. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
We're
appreciated
only
that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 applies,
Yeah,
that this change has to be brought in through a Constituent Assembly.
correct.
But this was evidently not the Constituent Assembly because A, it was the Legislative Assembly that you have invoked, and two, even that Legislative Assembly was dissolved and ultimately Parliament was exercising that power under 356.
Now, the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, whether that may be valid, may not be valid, but I can't answer that question in a vacuum.
But
My lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various princely states and.
Different, Mullah, those pacts were there, recognition granted to rulers, but Mullah, either they completely assimilated themselves into the union and be part of a state, or they were taken over. Either Hyderabad or Junagadh.
On the basis of certain agreements between the states and the princely
Correct,
states.
but those agreements were different from this agreement. Mullah, your lordship is right. If it were that kind of agreement, then your lordships would apply those standards and those principles and those judicial dictums which your lordships applied. We're not on that.
Here your argument is that unless the views of the entire populace of the Jammu and Kashmir are taken into consideration, the abrogation of 370 can't be
Yes,
served
that
upon.
can be done. But that's
then the negotiations were not between the elected body, the negotiations were
Because-
between the princely state and the union.
Correct, and that was accepted. That very thing was accepted by the then constitution makers. So, whereas we can't go into
So if what was accepted, insofar as the other states are concerned, it could be taken away by 363A.
Correct, but that was not the position as far as Jammu and Kashmir is concerned. I'm not saying anything. I agree with what my lord is putting to me. But how do you change the constitutional structure? There must be some power. You can say that you can do a political act. Today you say, look, forget about all this. We take over Jammu Kashmir. Fine.
363A was done under 368.
Yes, you can do that. But point today is, Mother, that's not an issue before you. You're not going to answer an issue which is not, with respect, the greatest respect, which is not before you. You're not going to find a power for them which doesn't exist and which is not followed.
Yes, Mr.
Go back. I understand, Mullah, the difficulty, and I understand, Mullah, the fact that at some stage or the other, this had to be, let's put it this way. This had to be done. Let's put it this way. Somebody said this has to be done. So then then well, there must be found a constitutional way of doing it. I'm not saying there are.
What has to be done, I would say, but whether it could be done or not.
No, not
That
could
means
be.
the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the
Yeah.
process by which they followed was.
Yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly. Absent a Constituent Assembly, you cannot exercise the power to abrogate.
Number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believed that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
Of the Parliament.
I'm not saying anything.
Article 212.
Yeah, so I'm just saying, 11 o'clock, nobody knows. Nobody knows.
Larger issue as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates.
Yes.
Volume 3.
You want us to read what now?
Volume 3, Manoj. Page PDF 323. And the fact of the matter is, Manoj, apropos what my learned friend said, almost all the laws applicable in the Union of India were applicable in Jammu. As of today, Manoj, I have a list, it runs into, pages after pages. Everything has been adopted, apart from other than the residuary power. Everything is adopted. Everything. It's like
Mr. Sibal,
100 and...
You are referring volume 3?
Yes, volume 3. Volume 3, PDF 323.
Case law.
Case law, volume 3. Yes.
No, there is a separate volume for
Case law volume.
Yes, sorry, Millet. Case law volumes. Yes. It's Coelho. Coelho, Millet.
Coelho and Rameshwar Prasad, they are in one volume.
Yes, leading Coelho, para 54, PDF 323. 323. Running page 776, Malak. Yes. 323, para 54. And remember this, if you use 368, you'll have to have 2/3 present and voting. So you don't use 368 because you don't get present 2/3 present and voting. So you go through this procedure. So the question whether 368 could have been used or not is a separate issue. And had that been used, we'd have had another argument here, but it's not an issue here.
Yes, Mr. Gunn. Which
I'm
is
just
the,
telling you
which
the
is the
hurdles
para
in
from Coelho that you would like us to see?
Yes, para 54.
At page?
Page 776, Miller's PDF 323.
Page 323.
Yes. The distinction is drawn, my lord has that paragraph? By the author between the making of a constitution by a constituent assembly which is not subject to restraints by any external authority as a plenary law-making power and a power to amend the constitution. A derivative power derived from the constitution and subject to the limitations imposed by the constitution. No provision of the constitution framed in exercise of plenary lawmaking power can be ultra-vires because there is no touchstone outside the constitution by which the validity of provisions of the constitution can be adjudged. The power for amendment cannot be equated with such power of framing the constitution. The amending power has to be within the constitution and not outside it. Why? Because you're subject to the constraints of the constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the constitution, you have to follow then what the constitution obliges you to do constitutionally. If 368 were available.
All right, apart from Coelho, which is the next?
Yes, next is para 118 of Coelho itself.
PDF?
PDF page 344. We have I'm sorry, para 118. We have earlier noted that the power to, my lords have that?
Para 118.
Yes. We've earlier noted that the power to amend cannot be equated with the power to frame the constitution. The power has no limitations or constraints. It's a primary power, a real plenary power. The latter former power, however, is derived from the former. It has constraints of the document, that is the constitution which creates it. This derivative power can be exercised within the four corners of what has been conferred on the body constituted, namely Parliament. The question before us is not about the power to amend Part 3. As per Keshavnan Bharti, power to amend exists in Parliament, but it is subject to the limitation of the doctrine of basic structure. The fact of validation of laws based on exercise of blanket immunity eliminates Part 3 in entirety. Hence, the rights test as part of the basic structure doctrine has to apply. So, Malads, therefore, we are now left with a Parliament which seeks to amend 370. So, therefore, it has to work within the constraints of the Constitution. That's what we're concerned with. We're not concerned with any other interpretation of the Constitution. So now we go back, Malas, to the list of, yes, the Ambedkar statement is volume, yes, document volume 8, PDF page 26. Yes. Volume 8, documents volume 8, PDF page 26. Now, Malas, quite frankly,
PDF page?
26. Just two paragraphs and then I'm done with this issue altogether, Malad. PDF page 26. Documents volume 8.
Eight.
You also have it? May I read it, Malad?
Page?
Page
Yes.
item 57, PDF 47 in my list of dates, volume 2 of the written submissions. Well, that's 20th of June, 2018. Section 92.
That we saw, Mr. Sibila.
Yeah.
That we saw, you read out section 9.
That's right. No, but what's important is the date. On the 19th of June, a political party in coalition with another party which was in government withdrew support.
That is not in a list of dates.
Yes, just kindly note that. It's in the proclamation.
19th of June 2018.
Yes, well, that's BJP withdrew support from PDF.
This is
PDP.
Before the serial number 57, no?
Yes, yes. It's in the document, but I just wanted to. It's the proclamation. Let's see then.
Yes, Mr. Sibila.
Now, so he issued, the governor on the next day issues a proclamation, which is also quite curious.
That we find at top of page
That
48.
your lordships may look at Millard's PDF page 85, volume 3, the proclamation itself.
Anything turns on it? I mean, in the sense to read it. I mean, you've paraphrased it, I guess.
Yes, I have paraphrased it.
Is there any
No,
particular
nothing.
sense?
The provision
Not
permitted the
necessary.
governor by proclamation to assume to himself all the powers and functions of the government of the state. Such a proclamation in one terms of 92(5) required concurrence of the president, and under 92(3) would cease to operate within 6 months, which I've already mentioned to your lordship. We need not go into.
This is the power corresponding to 356, which is vested in the governor.
That's right. That's right. But here it's vested in the
The governor.
governor, independent of the council of
Of the
ministers.
council.
which I mentioned to your lords. It's a very, very unique power. And the Council of Ministers was suspended in the process. Well, he didn't even wait for a day. I mean, is normally speaking, what would happen? Malas? A governor would wait for other political affiliations to take place to form a government.
That's also part of political process.
I'm sorry?
That's also part of political process.
That's precisely what I'm saying, Malas. But why do you think I've been saying this? Why would a governor do this on the next day, Malas?
Yes, then what happened?
Well, then, well, so he does this, so 6 months were to expire. Then, well, there is some controversy, and I just tell your lordships orally that controversy is. According to the PDP, and I think somebody else will argue that, I'm not arguing. According to the PDP, they send a fax to Srinagar that they have the support of the National Conference and they are willing to form the government. The governor says he never received the fax because he says that he was in Jammu and the fax was sent to Srinagar. So Malas, on the 21st of November, the next day, he dissolved the assembly. Yeah, on 21st November.
The facts of some
Fax is also sent
constitution
on
benches have a sense of deja vu, you know.
Fax is sent on 21st, he dissolves it on 21st. The fax hasn't reached him. Fax was sent.
It's almost on the annual of the period expiring.
No, that expired on 3rd of January, 19th of December.
19th, so about a month short of
Yes,
that.
yes, month short. Malas.
This is
Because-
not under challenge anymore.
No, no, I'm not,
That's
I
not-
myself said so. I myself said that that is an issue which.
So he dissolves the legislative
He
assembly.
dissolved the legislature. Now, Malas, you can't dissolve without the Council of Ministers. 36, 38 and 92 are his only powers. He has already suspended the Council of Ministers. He dissolves it.
Without the aid and advice.
Nothing. Why do you think I've been saying continuously that this is a pure political act? The governor and the government were acting in tandem. They wanted to get rid of 370. Toss it out. Why would any governor do that? Why would the governor on 20th of June, after withdrawal of support on 19th of June, suspend the assembly? Don't allow any political affiliation and parties to take place so that a new government can be formed.
Which is the power of dissolution under the constitution, just for the cross.
Yes, 53. Section 53 of the Constitution of Jammu and Kashmir gives that power of dissolution, not part of the exception given to the governor with reference to his powers that he can exercise without the aid of the Council of Ministers.
Yeah, because section 35 refers to 36, 38 and 92.
36, 38 and 92. The process, according to me, when you're interpreting constitutional provisions, is as important as the substance. Because it's a constitutional process.
That's what another Coelho says, but this time it's Paulo Coelho
That's
in The Alchemist.
That's right. Then, Malas, on the 19th of December, the proclamation of governor's rule expired. A proclamation under 356 promulgating president's rule in the state of Jammu and Kashmir was issued on 19th December. So then came president's rule. So on 3rd of January, want to show the proclamation? Well, it's better to see the proclamation, volume 3, PDF 92. Volume 3 of documents, PDF 92.
You want us to look at this, Mr. Sibyl?
PDF?
You want to?
Yes, I do. Let's see that, Malas. It's important. Because that's a very important provision. It has huge implications as to what happened later. My lords have PDF 92.
PDF,
92, Madas. Volume 3 of the document. Justice Gawai, Justice Kaul,
Yes.
Justice Surikant.
yes, it seems.
Yes.
The following proclamation by the President is published. I, so and so, have received a report from the Governor of the state of Jammu and Kashmir, and after considering the report and other information received by me. Well, it's all Governor's rule. Kindly see, Mullah. It's all Governor's rule from 20th of June right up to this date. There is no council of ministers in place. There is no government in place. But he sends a report that the government cannot be carried out. Where is the basis for any of that? There are no negotiations. There are no communications. So he says, I am satisfied that a situation has arisen in which the government of the state cannot be carried on. Government of the state, but the government of the state was carried on by the governor. In accordance with the provisions of the Constitution of India as applicable to the state and of the Constitution of Jammu and Kashmir. Now, in exercise of the powers conferred by Article 356 and of all other powers enabling me in that behalf, I hereby proclaim. Kindly come to C. A. Assume to myself as President all the functions of the government of the state and all powers vested in or exercisable by the governor in that state under the Constitution and the state Constitution. Declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. Now, this is important, Mullah. Therefore, Parliament will be exercising the powers of the state legislature. And the state legislature under Mullad's 147, you can't move a bill. Which is what Ambedkar said, which is what Keshav Nand said, that you can't do this. You have to be confined to your powers and responsibilities under the Constitution under which you're acting. So, declare the legislature of that state shall be exercisable by or under the authority of Parliament, make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of the proclamation. In exercise of the functions and powers assumed to myself by virtue of Clause A of this proclamation, as aforesaid, it shall be lawful for me as President of India to act to such extent as I think fit through the governor of the said state, the operation of the following provisions. Now, this is very important. Of the Constitution and of the state Constitution are hereby suspended. Under what power? So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so much of Clause 2 of Article 151 of the Constitution as relates to laying before the legislature of the state of the report submitted by the governor, by the Comptroller and Auditor General. Now, what they did was they took away the proviso to Article 3. Under what power? You can't amend the Constitution in virtue of your power under 356. Now, let's see what the proviso to Article 3 of the Constitution says, Mullah. Kindly have a look. Kindly give it. Volume 1. Constitution, Volume 1. Documents, Volume 1. PDF page 186. Sorry. 65? PDF page 65. Yes. 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 One second, hold on. So PDF page 65. This is an amazing piece of handiwork. It's a mosaic of illegalities. Attractive enough to be junked. I don't understand how this always happens. There must have been great constitutional advisors, Mulad, who would have thought of this very complicated handiwork, which found itself in our constitution. Bloody hell. Huh? Uh-huh. So, totally. So I brought it now. Right, right. So Article 3, Mother, document volume.
So they delete effectively the proviso to Article 3. But Mr. Sibal, at the end of it all, I mean, of course, this has the optics about the way it was done, but there's no challenge to anything that was done. All this is not under challenge here.
No, Mother, all once you are challenging the emergency, Mother, the declaration of 356 is challenged. Mother, just look at
What is
it.
the frame of the petitions? Do we have a challenge to
Yes,
the
we have one challenge. But Mother, quite apart from that, you're looking at Mother, it's in
Yes.
grade 370, Mother. I mean, it's not. But
All right, we just see what the frame of the challenge. If you can just ask one of the juniors to make that little tabulation for us.
But apart from that, Mother, this is now before you.
Yes.
In all its various
Nuances
parts, in
and-
a sense.
Yes, of course.
Now the question is, Mother, what is the power? And that's the other thing. What is the power under 356? The quintessential object of 356 is to restore democracy. You take over because a government cannot be run in accordance with the provisions of the Constitution for a temporary period for the restoration of democracy. You don't use 356 for its decimation. You can't amend the provisions of the Constitution under 356. Of 356. We'll give it on Tuesday. We have to show the Constituent Assembly.
require ratification by the state legislatures. Now, suppose a particular state, the legislature, the power has been exercised under 356 and the president assumes the powers of the legislature, the executive. Can a ratification be done under 356 in relation to that particular state legislature?
No, Malaj. No, because he's exercising powers as a state legislature, Malaj, in this sense. There is no question of ratification.
Not in the J&K case. I'm
Yes.
just theoretically, I'm saying, can a,
Generally, what is my lord is putting to?
some constitutional amendments under the proviso
Yes.
require a ratification.
That's right, that's right.
Now, for the purpose of computing the majority, computing the strength required for ratification,
Yeah.
can the center fall back upon the exercise of the 356 power? Say that, look, we have ratified it because we were exercising the power under 356.
Tough question.
Has never
What my lord is
happened, but
putting to me is that if Jammu and Kashmir, in a 368 situation, if Jammu and Kashmir were to ratify it, then Parliament can exercise that power.
suppose any Indian state,
No, Malaj.
you require a certain number of states.
Provided, Malaj, the 356 is imposed there, not otherwise.
But if 356
Yeah.
is imposed, then can that power to
But that's-
ratify the
that's a tough
amendment be
question.
exercised?
That's a tough question.
Even that is a little.
Yeah, it's a tough, I can't answer it.
Yeah,
right
even
away.
I-
I'll have to think
just-
more
I-
about it. Because the ratification is of the state, therefore there are two separate constitutional authorities. One parliament passing the law and
And then the
another
state.
authority ratifying it. You can't take the position, that's like, it takes two hands to clap. It's the same analogy. Therefore, you can't exercise that power yourself because that's power constitutionally is provided for in another institution, in another constitutional body.
Now here the proclamation comes under 356.
That's right.
After that, what is done then?
Then, Malaj, they amend section, Article 3.
We saw that.
Yes. But Malaj, kindly see, just read Article 3 with me for a minute. Formation of new states, alteration of areas, boundaries or names of existing states.
Amendment to Article 3 required as part of this whole process.
Because they wanted to get rid of this proviso, Malaj. Otherwise, they wouldn't
Let's
have
see
been
the
able to.
proviso.
Yes. Because then you have to do the Reorganization Act.
Or the reorganization.
Yeah, that required.
Converting the state into a
That's
UT.
right, that's right. That's how this had to be done earlier. Second proviso is not your lordship's document, that has been the other document. The second proviso relates to Malaj as applicable to the state of Jammu and Kashmir. Kindly have a look at that. Kindly just show that document.
Document volume 1.
Volume 1.
Of the order passed,
Yes. There the proviso is there.
there the proviso was,
That's correct.
that proviso is deleted.
That's correct.
Which is that proviso?
Which requires, I'm going to show that to you, Lordship. PDF page 65, document volume 1.
That was,
Yes.
that must be pursuant to the presidential order.
Correct, absolutely right.
So the presidential order was not, was the presidential order amended? No.
No. That's interesting.
It has been superseded, my lord.
It deals with the second proviso. You can't even introduce the bill, forget about anything else.
Or only one second provision.
Second part of the first proviso and the second proviso.
Where do we get this document? Actually, it's document number, document compilation,
Documents, volume 1, PDF 65,
65.
Constitution of India as applicable to the state of Jammu and Kashmir.
At page,
PDF 65, running page, Malaz, is 65, also 65.
That's the Constitution of India is applicable to the state of Jammu.
That's where the only place where the pages of the Constitution of India and the Constitution as applicable synchronize, Malaz. The rest is,
I interestingly read the note below. It says when secular was inserted into the Constitution,
yeah.
it was never inserted here.
I see. Never inserted, okay.
Just see the note below
I
it.
got
Note,
it, I got
note 1, you got it?
Yes, I got it at the bottom, yes. Socialist secular.
Socialists agree.
But see, Malaz, what they've done.
where is the proviso?
Proviso, Malaz, at page 66, next page.
Second proviso.
Let's read the whole, Malaz. It'll be better
Yes.
if we read the whole. If you don't mind.
Yes.
Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may by law form a new state by separation of territory from any state. Malaz, this is also be important when you deal with the Reorganization Act. You might as well read the whole article, Malaz. Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless, where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon, which within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed is expired. That's why, Malaz, when the views of states was taken, Malaz, they said, no, you haven't referred it. We said, only need to take your views. We don't have to take your consent or your concurrence. So we may not agree. Even if you express your views that it should not be done, we're not bound by it, which is the correct constitutional provision. Then the second proviso, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So you can't even introduce it. Here by 356, you do away with it.
They have created a UT. Otherwise, they have not altered the territory, have they?
No, they haven't.
No.
Ladakh is not part of the state anymore.
That's what they carved out a UT and
Yeah.
made another UT, which they say.
Yes, carved out a UT saying that this will become a state,
Yeah.
and the other UT will remain a UT.
UT. So carving out a UT is permissible, no?
But boundaries are.
Not from a state, I'm sorry. You can't
Boundaries are
create a
altered.
whole state as well.
Boundaries are also.
Yes,
altered.
boundaries are also altered.
To that extent, yes.
So, Malaz, this is all. And Malaz, there is and I'm going to take your lordship to the Constitutional Assembly debates on this. Just presently, I'll do that.
And for J&K, consent is required.
Yes.
Not just
No.
the views, but
Yes.
the consent. Other states,
No, Malaz, you require the consent before you introduce it.
right.
Yes.
Other states, it's only the views have to be taken,
That's
but for J&K, the consent is required
Before you
to introduce the bill.
Yes. I'm sorry.
Okay.
Is it mentioned only in 1954 constitutional order or is it incorporated in Article 3 also?
It's mentioned in the 54 order and incorporated in Article 3 before the 54 order.
If
Yes.
it is incorporated,
Yes.
that would amount to amendment of the constitution. Then was it followed as per Article 368?
Not in the Indian Constitution, Mother. It's only in
Article
this Constitution.
This proviso, second proviso,
Yes,
you are reading.
yes.
Now we are reading it on the presumption or assuming that it's a part of Article 3 of the Indian Constitution. Second proviso.
No, it's a modification of Article 3. As applicable. As applicable only.
So it is only incorporated in the 1954 order,
As a,
not formally inserted in Article 3 of the Indian Constitution as a second proviso.
correct, correct, correct. Absolutely right, what my lord is putting to. Absolutely.
They suspended the operation of
They
this.
suspended the operation. Now, how do you get that power under 356? That's not the object of the proclamation.
Deleted, suspended.
Then they exercise.
That assembly can't exercise that power unless to suspend.
On behalf of the assembly.
Yes, they can't do that also. A bill cannot be introduced without the consent. Assembly is not in session. There is no assembly, it has been dissolved. So where do you get the consent of the assembly? So the governor becomes the assembly, then the assembly becomes parliament, and then parliament gives consent. On behalf of an assembly that doesn't exist.
Mr. Sibal, what was the procedure followed when different orders were issued under those constitution, right? Like those about 18 orders,
Yeah.
constitution orders,
Yeah.
1952 up
Yes,
to.
all mandates with concurrence. With reply, with
What was the procedure followed?
procedure
Was it through parliament process or through by the president only?
No, it's not through a parliament process, it's through a presidential notification after taking the consent, concurrence or consultation. That's right. So that's how it's made applicable, through a presidential order. No. So it's 356 and exercising powers under 356. It's a Well, in this context, before I go back to 356, it's better to your lordships looks at the Constituent Assembly debate on this. On this Article 3 and why this was Volume 8. PDF page 289. Which Dr. Ambedkar Maharaj at 289 says, "Sir, I move." Yes. Yes. There's sir, I move that for the existing proviso to Article 3, the following proviso be substituted. provided that no bill for the purpose shall be introduced in either House of Parliament except in the recommendation of the President, and unless where the proposal contained in the bill affects the boundaries or name of any state or states for the time being specified in Part 1 of the first schedule, the views of the legislature of the state, or as the case may be, of each of respect to the provisions thereof have been as contained by the President and the states, both with respect to the proposal to introduce the bill and with respect to the provision thereof, have been ascertained by the President, and where such proposal affects the boundaries or name of any state of states or states for the time being specified in Part 3 of the first schedule, the previous consent of the state, or as the case may be, of each of the states to the proposal has been obtained. Mr. Vice President, if one were to compare the amended proviso with the original proviso, as it was set out in the draft constitution, members will see that the new amendment introduces two changes. One is this: in the original draft, the power to introduce the bill was given exclusively to the Government of India. No private member of Parliament had the power under the original draft to propose any legislation of this sort. Attention of the drafting committee was drawn to the fact that this was a somewhat severe and unnecessary curtailment of the right of the members of Parliament to move any motion they liked, and in which they felt concerned. Consequently, we deleted this provision, giving the power exclusively to the Government of India, and gave it to the President, and stated that any such bill, whether it was brought by the Government of India or by any private member, should have the recommendation of the President. That is one change. The second change, which is more important, is this: under the original Article 3, the power of the Government of India to introduce legislation was restricted by two conditions, which are mentioned in A1 and 2I. The conditions were that there must be, before the initiation of any action, representation made to the President by a majority of the representatives of the territory in the legislature of the state, or a resolution in that behalf passed by the legislature of any state, whose boundaries or name will be affected by the proposal contained in the bill. Here again, it was represented that there might be a small minority which felt very strongly that its position will not be safeguarded unless the boundary of the state were changed, and that particular minority was permitted to join their brothers in the other state, and consequently, if these brothers remained there, action would be completely paralyzed. Consequently, we propose now in the amended draft to delete 1 and 2. This is important. To delete 1 and 2 of A and also B of the original draft. These have been split into two parts, A and B. A deals with reorganization of territory insofar as it affects the states in Part 1. That is the Dominion states. Part 1, that is to say provinces, and of the new amendment relates to what are called Indian states. The main difference between the new clause A and B of any amendment is this: in the case of A, that is to say reorganization of territories of states falling in Part 1, all that is necessary is consultation. Consent is not required. All that the President is called upon to do is to be satisfied before making the recommendation that their wishes have been consulted. With regard to B, the provision is that there shall be consent. The distinction, as I said, is based upon the fact that as far as we are at present concerned, the position of the provinces is different from the position of the states. The states are sovereign states and the provinces are not sovereign states. Consequently, the government need not be bound to require the consent of the provinces to change their boundaries, while in the case of the Indian states, it's appropriate in view of the fact that sovereignty remains with them that their consent should be obtained. As regards the amendment moved by Professor Shah, I do not see much difference between my amendment as contained in subclause A of the new proviso and his. He says that the discussion shall be initiated in the states. My subclause A of the proviso also provides that the states shall be consulted. I have not the least doubt about it that the method of consulting which the President will adopt will be to ask either the Prime Minister or the Governor to table a resolution which may be discussed in the particular state legislature, which may be affected, so that ultimately the initiation will be the local legislature and not by the Parliament at all. I therefore submit the amendment of Professor Shah is unnecessary. Now, this was adopted, Madam. So the views of the people of the state were to be taken. So the second proviso, Malads, when it came in, they said that this will not apply to Jammu and Kashmir. It needed consent. And so therefore no bill could be introduced. This is consistent with all the provisions, including 370, including the powers of concurrence, Malads, with respect to the concurrent list in the concurrent list of the Constitution as applicable. So this is a consistent thread throughout, which is accepted by the constitution makers. So now, Malad, if you now go to 356, document volume 3, no, this is very, PDF page 92, I'll read further, Malad. So they suspended this.
Document volume 3.
Yes, Malad, volume 3, PDF page 92. That's the proclamation. So when everybody was all states were integrated into the union, that means you didn't need any consent. But since this was not integrated, Jammu and Kashmir, therefore the second proviso was provided. And Millers, your lordships will see that the whereas clause says provisions of the Constitution of India as applicable to that state and of the Constitution of Jammu and Kashmir. Both. And now, Millers, so much as the first proviso to Article 3 as relates to the reference to the President to the legislature of the state, and the second proviso to that article, so much of clause 2 that we don't need to read that. Then, Millers, kindly item 3 of the proclamation. Any reference in the Constitution and the state constitution to the governor shall, in relation to the said state, be construed as reference to the president. And any reference in the Constitution and the state constitution to the legislature of the state or the houses thereof shall, insofar as it relates to the functions and powers thereof, be construed unless the context otherwise requires as a reference to Parliament. So governor functions to Parliament, legislature functions to Parliament. So it's all Millard's. The power is concentrated in Parliament to do what it likes. And in particular, the reference to section 91 of the state constitution to the governor and to the legislature of the state or the houses thereof shall be construed as references to the president and to Parliament, or to the houses thereof respectively. So, Malas, you lose the link between the center and the state altogether. You absorb the powers of the state with yourself as the executive as well as Parliament as the legislature. And you decide without reference to any other institution. Governor means president, legislature means Parliament. So you can do what you like. And so you give yourself consent. You don't have to seek consent. And the people who gave themselves this constitution are left out of the process altogether. This is essentially, according to me, a breakdown of the constitutional structure that was engrafted in the Constitution. It's a complete breakdown. By inhering in yourself as the union, the power of the state, executive power of the state, and by Parliament, the legislative power of the legislature. So you do away with any representative form of government, do away with institutions, and make it irreversible.
Yes.
Then let's go back now to the list of dates. PDF 48. Written submissions compilation volume 2, PDF 48. So I've done with the proclamation 19/12/2018. So item 60. My lords had that. A resolution approving this proclamation issued by the President on 19/12/2018 was passed in the Lok Sabha on 28/12 and the Rajya Sabha on 3rd of January. Then, brothers, we don't have to read this. Jammu Kashmir peoples, we're not concerned. Kindly come to 60, item 65, PDF, page 50. So at item 65, you will find on the 3rd of July 2019, the President's proclamation was in terms of Article 356(4) to expire on 2nd of July. 6 months, mothers. Because from January 3, 2019, it would be July 3. So it was to expire on 2nd July. Consequently, President's rule in J&K was extended for a further period of 6 months with effect from 3rd of July till the 28th of June 2019 and Rajya Sabha on 1st of July. Then leave all this. Then 72, page 53, PDF page 53. This is that 11 a.m. order on the 5th of August 2019.
We'll break here. Mr. 3 minutes short. We are going to the 11 a.m. order now. We'll continue with this on
We'll wait
Tuesday.
for 11 a.m. the next day. I'm deeply obliged. We appreciate your Lordship's patience, Madam.
We'll come back on Tuesday.
Yes.
Tuesday, no?
Lordship, on matter, the High Court has pronounced the order that my lord had remanded to them. We filed an SLP against that. We sent the email as per the protocol,
Certainly.
requesting for a listing. Lordship, because they may not proceed with the survey.
I'll look at the email right away.
Grateful.